Hi, today me and my friends are going to give presentation in the case between the Australian Securities and Investment Commission, which is considered as the plaintiff, versus Martin Stott as the defendant. This case was happened there in Melbourne on the date 15th of February 2010. Okay, let's begin with the introduction. Actually, the director of the company in Australia or any part of the world, even the officers of the company have been given the certain powers and duties due to the reasons that they run the company on the behalf of the shareholder of the company. All the power that have been given to the directors, along with the obligations which have been imposed on them. These have to be discharged in the proper manner, which works in the interest of the company instead of the personal interest of the company. These types of obligation has been imposed through the Corporation Act 2001 by the government of Australia. Similarly, I want to describe what happened among the Australian Securities and Investment Commission versus Soust. Soust is the CEO and the managing director of the Select Vaccine Limited. He actually placed the bid through the telephone to the stockbroker on the December 31st, 2007, late in the night, which was happened actually outside the permissible trading windows. Till that moment, the last pre-racing sale was undertaken at 2 cents for each share. Soust, he knew that the lack of the market depth would mean that a number of the trade would be needed for fulfilling his order, and that would result in the price being driven up beyond the value of 2.4 cents for each share, which is the last offer price. He immediately transacted at this price, and within the minute or two more, trades were made at the 2 cents for each of the share, which was a dramatical change. This resulted in the price being raised by the 19.05% in an instance in the comparison to the prices of the previous year on the same date, which was at 2.1 cent for each share, and this would enable the share price to outperform the index as required by the executive service agreement terms. In case this trade has not been made, there would have been a decrease in the share prices by 4.76%, and the share would have been underperformed in the index by 3.27%. The board meeting, there are various different types of board meetings, and the meeting of the remuneration committee, which were attended by Mr. Soust. And in this meeting, he failed to disclose that a trade had been made by him, due to which the share price was raised from 2 to 2.5 cents for each share. Due to this non-disclosure, the board could only acknowledge the fulfillment of the criteria laid down in the Soust service agreement, and hence he was paid the performance bonus. This would certainly be avoided in the involvement of the Soust in the transaction was known. The remaining part I want to hand over to Mr. Season.
Thank you, Mr. Assis. I would like to talk about the duty of breach in this case. According to Section 181 of the Corporation Act 2001, civil obligation imposed over the directors as well as the other officers of the company to act in a manner which shows good faith, and the actions have to be undertaken for the purpose proposed, while the best interest of the company is kept in mind, while the duties are discharged and the powers are exercised. Through Section 182 of this very Act, another civil obligation has been imposed over the officers and the directors of a company, whereby they are prohibited for making an improper use of position which they hold in the company, in such a manner which is detrimental for the company and due to which a portion advantage or a disadvantage for someone else is attained. The contravention of both of these sections attracts the civil penalties, as are contained in section 1317E of this Act. This section empowers the court to make a declaration of contravention according to the WIPO 1015. Once this has been made by the court, the ASIC can apply for penalties on the basis of section 1317G of this Act, along with making an application for disqualification order pursuant to section 206C of this Act. Furthermore, on the decision of the court, I would like to give some points as per the director's duties. Soust has to make a proper use of his position, where the interest of the company had to be kept supreme. However, Dr. Martin, just to make the bonus which otherwise he would not have to been able to make, he made an improper use of his position and did something which was ultimately detrimental for the company. Hence, he contravened two separate directors' duties, that is, failure to act in the best interest of the company and making improper use of the position which he had in the company. Dr. Martin not been involved in such transaction, or had he disclosed the transaction made to the board, he would not been a bonus for which he undertook this transaction. Soust not only breached the share trading policy of selected vaccines in that deliberate manner, he consciously lied to the board, which showed the severity of his conduct, along with the nature of his conduct, according to Australian Legal Information Institute 2010. As we are in the conclusion part of this case, to conclude this case shows that the directors are required to refrain from the interfering in such activities which result in them gaining an advantage for themselves. And even when they enter in such transactions, it is their duty to make proper disclosure about the same to the board of the directors and other places where they need. This will allow the obligation imposed over the directors of the company to be fully in eternity. In case the same is not done, it will result in a contravention of the director's duties. At the last, in this particular instance, along the breach of director's duty provisions, the provisions with regards to the misleading and deceptive conduct were also breached. Thank you.